So good morning, everyone, and thanks for being here. We kick off the event, but I think preliminarily we should introduce ourselves because I'm sure that many of you are questioning what is the International Tax Law Research and Policy Network that brought us together here to discuss on the topic of permanent establishment. So it's simply a network of independent experts coming from academia and private practice. The aim of the network is pursuing the aim of research in the area of international taxation and advancing discussion on relevant international tax topics. Before we start, I wish to thank all the co-organizers and co-ventures in this event. It's a second event that follows an event that took place last year in Belgrade. And in strict alphabetical order, I would like to thank Paolo Arginelli, who is Italian professor at the Catholic University of Piacenza and a colleague and partner at Pirola Pennuto Zei. Andres Baez Moreno, who is a Spanish associate professor of tax law at Universidad Carlos III de Madrid. Vikram Chand, who is a Swiss professor of law at the University of Lausanne. Raffaele Petruzzi, who is a managing director of the VEU Transfer Pricing Center and CEO of Petruzzi Advisory. Svetislav Kostic, who hosted last year's event in Belgrade, for which we still owe you a big thank. The event was, I believe, a remarkable and fantastic opportunity to get together and discuss on the topic of global mobility. And it also paved the way for this second event, which, for the sake of clarity, is meant to be a transitional event, because the Belgrade event was a two-day event. This one is a one-day event, and hopefully more and bigger events will come in the future. We are already planning on that. And then, last but not least, there is myself, Mario Tenore. Again, still many thanks to all of you for being here. The event is really the outcome of a joint multi-jurisdictional, because we have co-organizers from various jurisdictions and personal efforts. Without those efforts, this event would not have been made possible. The topic of this year is permanent establishment, and particularly recent trends on permanent establishment, business, nexus, and profit allocation. The speakers of the event are shown on the program. They include renowned experts with various backgrounds from academia. We have prominent professors, Italian, but not only Italian tax professors, representing 9 different universities. We have people from private practice, international corporate tax and transfer pricing experts, tax directors from different multinational entities, as well as senior experts from public institutions, including the OECD and the European Commission. I'm very thankful to all of them. I'm very thankful to you for being here today. And now I leave the floor to my colleague, Paolo, to join the opening remarks with some additional inputs. Thank you very much.
Thank you, Mario. Well, we obviously would like to thank also our university. I'm not going to tell the name of all of them again, but you just heard, and it was important for us, coming from academia, to have them backing up us for the entire process of setting up this conference, which has been a big effort. Secondly, we would like to remark our appreciation for the support that Assonime, which is the Association of Italian Stock Joint Company, have gave us during the process. But most of all, we would like to thank our sponsors, because we have 17 top-ranked law firms from 8 different countries, and they provided us with the technical and financial means to realize this conference. Without their support, we wouldn't be here in this beautiful environment today. So thank you to the sponsors. And I'll try to be brief, because we have to be strict in time management, and we are already 20 minutes more or less and delay, this thing that I really don't like. So just 2 things with regard to the program, 2 small changes. Unfortunately, Vice Minister Maurizio Leo, that is active for the tax reform in these days, couldn't be here due to urgent and unexpected institutional commitments, but is sending his regards to all of you. And therefore, we will gain some more time, because it's not intervening, which is good for time management. And second, we should have had Mauro Fagion from the European Commission within panel 4 this afternoon. However, we decided at the end to ask him to intervene as keynote speaker at the beginning of the afternoon, and therefore we will ask you, please take note of this, to reconvene here slightly earlier than forecasted. So we'll start the afternoon session at 20 to 2 in order to give the opportunity to Mauro Fagion to discuss about the recent proposal by the European Commission of the so-called BEFIT package. And he told us that he's also going to bring some nice surprise from the Commission. So I think on my side it's all, so we leave the floor to the actual conference, so we might really kick off. And I have the pleasure to leave the floor to friend and colleague at university, which is Cattolica University, Marco Allena. Please, Marco.
Thank you, Paolo. Thank you very much. Thank you to you and to Mario for this organization. So a very warm welcome from my side too. This is the 2nd edition of this convention. I'm very honored that my university, Università Cattolica, was invited and now has joined to this network. We weren't at the first, but now here we are, and we are very pleased to be here with also VN University and Assonime, as Paolo said. I'd like to apologize too for the absence of the Vice Minister Maurizio Leo, because we had spoken with him, with his secretary, but in the last days in Italy we had a lot of news about state balance, tax reform and so on, and so they are cancelling everything, I think, by now to the end of the year at last. And I apologize too for the absence of our tax agency, because we should have had here a representative from the tax agency, from the central direction, but they had some organizational problems and they couldn't send here anyone, but they pleased us to tell you and to give you a warm welcome. So Paolo told me to be very brief, so I will not mention the panels. We'll have 4 panels this day. I just mentioned the first one, and it will be chaired by Pasquale Pistone and Mario Tenore, obviously. And the last one, the conclusion remarks, will be chaired by my friend and very famous Giuseppe Melis, and very thank to both. Just a few things, because before giving the floor to the speakers, I wish to highlight the absolute topicality and the centrality of the themes of today, because it's enough to think of the evolution of the concept of permanent establishment and to the evolution of territorial connection criteria relevant for income tax purposes, as well as to the changes operating conditions of multinational groups. Not to mention the adaptation of territorial connection criteria and its application to the digital economy, and the related problems concerning the taxation of elements of wealth that often have no material or territorial connection with a given state. Actual issues which attempts have been made to compensate for by establishing replacement taxes, such as digital taxes in many countries. Or again, think about the guidance under Pillar 1 and Pillar 2 of the OECD matrix, the proposed introduction of a global minimum tax also in the European Union, as well as the opportunity to think at a progressive shift of tax revenue to the indirect taxes, which are traditionally more market-based, and to environmental taxation, also from a Pigouvian perspective. Given this scenario, the highly qualified, distinguished discussant and broad variety of topics covered in the 4 panels, today's study day sets out to be a springboard for fruitful discussion for all participants. So I wish you, thank you all for your joining today and officially declare the proceeding open. Thank you very much.
Now leave the floor to Luca Occhetta.
So, good morning, everybody. I will be very quick because, as Paolo said, we have just run out of time. So just let me welcome you all at this conference, and let me thank you all the ITL RN members for organizing it, and all the panelists for being here. And so maybe I'm a little partisan, but a special thanks to Paolo and Mario, now partner of our firm, for their special effort in organizing everything. As co-managing partner of Studio Pirola, I'm very proud to be to be a sponsor of this conference and to sponsor together with many other tax and law firms and private organizations. And I think that the presence of so many sponsors, as Paolo mentioned, and the support of prestigious university is for sure a clear indication of the technical relevance of the event. And I'm sure that the second appointment of the ITL Research Network will be at least as successful as the last year event that was held in Belgrade. At least, I think it will be successful for the importance of the topic under discussion. So actually the issue permanent establishment has become more and more relevant, and this is especially true in these days, I think. And a couple of inputs. Groups are implementing more and more lean and matrix-structured organizations, which have an impact on these issues. And another input, smart working, now originally boosted by COVID-19 pandemic, is taking an increasing cross-border dimension, so with consequences. But in general terms, the issue PE is crucial if we consider that it may have not only an economic impact in terms of possible double taxation, but also, well, at least if I think at the current Italian tax framework in terms of administrative and criminal penalties consequences. Well, I'm saying current tax system because you all know, or at least the Italian part of this audience, that the Italian Parliament approved recently a new framework, so an enabling law for a major tax reform. And among the many general principles and criteria that have been approved, enabling, as I said, the government to reform the Italian tax system, I want to recall here Article 3, which calls for a review of the tax residence rules for individuals and companies aiming to align domestic provisions with international best practice and so double tax treaties that have been signed by Italy. But I want to focus the fact that this includes a coordination of tax residence criteria with permanent establishment rules, when it comes to individuals moving to Italy to work remotely. So I can go back to the smart working issue, which may have impact in the permanent establishment issue. So, but just want to finish because it's okay. So I just wanted to say that I'm sure that in light of all the above, that the debates of today's conference will contribute to identifying fair, pragmatic, long-term solutions and try to guarantee an appropriate balance between public interest and demand for efficiency and legal certainty of all the economic operators. So good work, everybody. So I leave the floor to Paolo again. Thank you.
Thanks, Luca. I would say that indeed the first part of the conference, the kickoff, is over. So now we're ready to ramble. Mario, the floor is yours.
I'd like now to call the next intervention, the introductory speech on the relevance of the topic that will be given by Philip Baker, who is connected from London. Philip Baker is a well-known tax expert, is King's Counsel, visiting professor at the Oxford University and barrister at Field Court Tax Chambers. So, Philip, can you hear us?
Can you hear me?
Yes, very well. Good
I
morning.
hope you can see my slides as well. I'm sharing my slides.
We see them.
Lovely, excellent. Let's go, actually. Good morning, everybody. Buongiorno. Thank you very, very much indeed for inviting me to make a very short input statement at the beginning of this conference. I'm very conscious of the time, so I'm only going to make a couple of very brief comments. I've been asked to talk about the relevance of the conference. I don't think I actually need to say very much about this because the previous speakers have all referred to aspects of the relevance, and the very fact that you're attending the conference indicates how important you regard it is. And it's been a dominant topic for a number of years. I imagine the reason I've been invited to speak here was because almost 20 years ago, Richard Collier and I wrote the IFA Cahier on the attribution of profits to permanent establishments against the background of the OECD work on the topic. And we warned then that the AOA, the authorized OECD approach, would not work. Unfortunately, the Cahier came rather late to stop the work from continuing, and one of the problems we have today arises from that, and I'm going to pick that up in a moment. You know, all of you that are here, that the permanent establishment concept itself is fundamental to international tax because it's the established nexus requirement for host state taxation, taxation of non-residents who are hosted in a state on their business profits. It's been the established nexus for well over 100 years, and we have 100 years of refinement of the PE concept with case law, with commentary, with wonderful books like Arvid Score's book on permanent establishment. But that developed the PE concept in a very different economic environment with a focus on the physical presence of persons or property, premises in a jurisdiction. And that's one of the problems we face today. The PE concept is so central, but it was developed in a different time and a different era. It's not just relevant, though, for taxation of business profits. Think about other ways in which we use permanent establishment. A couple of examples. It determines for a non-resident the taxation of passive income, because we have to look to see whether the non-resident has a permanent establishment and whether dividends or interest or royalties or other income are effectively connected with the permanent establishment. It's also important for employment income. How often one finds a non-resident company that's not making any business profits in a jurisdiction, but they have a permanent establishment and they have employees who are working in the jurisdiction, and the taxation of those employees is impacted because it's borne by the permanent establishment. So PEs is such a fundamental concept. Even leaving the whole area of direct taxation, the permanent establishment concept has influenced the development of VAT with the business establishment concept, which is going to be discussed a little later today, which is similar to but not identical to the permanent establishment. I mentioned very briefly, the work that Richard Collier and I did on the attribution of profits to permanent establishments, the OECD carried out one of its longest projects to date on the attribution of profits, starting in 1998, ending up with a new version of the model in 2010. As you all know, that sought to apply transfer pricing approaches on the basis of a hypothesized functionally separate enterprise. And the whole work produced the authorized OECD approach, the AOA, I think a very much misnamed approach, because it's authorized as coming within the interpretation of the new wording of the model. It suggests that it's somehow sort of it's the only approach that the OECD accepts. It's not correct. It's a misnomer there. But that development of the AOA has been, as Richard and I identified, very problematic, not least of which that it conflicted with existing treaty norms. And I would say that one of the relevance of this topic is that that project provided the first really clear evidence of the fact that the OECD fails to provide global leadership in international tax, and that it's not the body that is suitably placed to develop principles of international tax, because after all this work, it produced an AOA which was not only rejected by the UN Committee for Developing Countries, but almost a third of the OECD member countries reject the AOA itself. And I remember and pay tribute to the New Zealander, who by and large led the fight back against the AOA, pointing out that it was not good for developing countries and it should not be adopted. The result is that there is no generally accepted approach to the attribution of profits to permanent establishments. And that gives a real problem when we come to perhaps one of the most significant issues of modern taxation, the issue we've been focusing ourselves on for almost 10 years, and that's the taxation of the digitalized economy. Because the biggest problem, or perhaps one of the biggest problems of the taxation of the digitalized economy is that non-resident businesses can earn a very great deal of profit from a country through digitalized supplies, through downloading of material or providing online services without a permanent establishment. And the fact that the PE concept has this emphasis historically on physical presence means that we don't have this traditional nexus, and we have to look at alternatives. We can, of course, come up with alternatives, synthetic permanent establishments. We can extend the PE concept to dematerialized activities. We can look for a significant economic presence. We can have a digital PE concept, but that doesn't solve the remaining problem that we don't then have a method of attributing the profits to those synthesized PEs. And that's where the failure to develop a proper attribution method leads us with the difficulty we have at the present moment of deciding, can we not have digital service taxes as an alternative to the traditional approach of identifying the profits of a non-resident and taxing there. So the topic is hugely relevant because, frankly, we are struggling these days with a number of very major problems. We have a PE concept which works for traditional businesses, but which is increasingly out of date for modern digitalized businesses. We have, and this is, I say, a really major problem, the absence of an internationally accepted attribution approach, and the problem that the OECD, having this misnamed authorized approach, can't now ditch it and say, that was a mistake, we should never have adopted that, let's go back to the drawing board and come up with a new attribution approach, maybe one that involves a former apportionment approach rather than a transfer pricing approach. We have, saying the same thing, an AOA which is increasingly being shown as Richard and I identified 20 odd years ago as unworkable. We also have, and this is an issue not so much relevant to me any longer in the United Kingdom post-Brexit, but we have increasing issues of the compatibility of the PE approach to EU law. Think of how many CJEU cases now concern the taxation of permanent establishments in other countries. So I don't think there's any reason for me to say anything more than that about the relevance of the topic. I don't think anybody would doubt how relevant it is. And with that, I am going to close my comments precisely on time at 20 past and hand over to John Peterson, who I'm looking forward very much to hear what John has to say. Thank you very much for the invitation.
Thank you, Philip.